All rise. The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. And welcome to this special session of the Iowa Supreme Court held at the University of Iowa College of Law. We have one case that will be submitted this morning. That case is in re the matter of Coe College. And we'll first hear from Ms. Baumann.
May it please the court, counsel. I'm Teresa Baumann. I represent the appellant Coe College. The case today is about a gift of famous paintings and language in a gift letter that was written on February 16th, 1976. This is the day the president of a charitable organization called the Eugene C. Appellee Foundation wrote a letter to the Coe College chancellor informing the chancellor that the foundation was giving a gift. The gift was 7 Grant Wood paintings. At that point, the paintings had been on display on campus for about 19 years. During that 19-year period, they had been on loan from Mr. Appellee. Mr. Appellee was a hotel owner in Cedar Rapids who in 1932 had commissioned the now famous artist Grant Wood to paint a mural, which in 1957, he decided that the mural should be divided up into 7 paintings and loaned out to the college. At that point, the loan was for an indeterminate term. In 1957, the loan to the College of the Paintings was with the understanding that they could be taken back by Mr. Appellee at any point after 1 year of being at the college. Since then, the paintings have been consistently treated for over 40 years since the gift in 1976 as an outright unrestricted gift.
Yeah, that may have been wrong, don't you think?
I'm sorry, I couldn't hear you.
That may well have been wrong, the treatment over the years in light of the language in the gift letter. And of course, the language includes the paintings are given to Coe College and that they would be part of the permanent home hanging on the walls of the library. So your current auditors came to the conclusion that the latter language was important. Wasn't that right? And isn't the problem here really that your auditors have made a mistake over the years?
Your Honor, this isn't a case about an accounting error. This is a case about good governance, if you would.
Well, it's a case about the language of the gift that expressly talks about it will be permanent and hang on the walls of the library. What about that's ambiguous?
The language has to be considered in the context, as this court has said, based on the restatement second of contracts in the context of the surrounding circumstances. If you look at those surrounding circumstances, Your Honor, has to be looked at, that word permanent has to be looked at in the context of the change in relationship. So prior to 1976, it was a loan relationship.
So permanent means temporary.
Permanent does not mean temporary, but it doesn't mean perpetual either. There's a case that...
Let's assume you went back to 1976 or 77, whenever the plaque was installed in the library, and you have a representative from the Appellee Foundation there, and they're going to unveil it with the plaque, and somebody from the college says, actually, we decided to sell it and use the money for the endowment. Do you believe that that action would have been consistent with the Appellee Foundation's intent and they wouldn't have objected at that time?
Your Honor, it'd be wholly speculative for me to say what would have happened at that time about a possible sale of the paintings. The fact is the paintings have been at the college for 40 years and the college has not sold them in that amount of time. And what's more important is the purpose. If you look at the purpose of the foundation, it was a giving organization. It had really 2 main purposes: to promote the well-being of mankind, a very general purpose, as well as to give, to donate to charitable organizations. Those were the two prongs of the purpose of the foundation. So when it was wrapping up its affairs in 1977, 1976, it was giving away its assets.
Could I ask you about the memorial? What does the record show? What's the size of the plaque and the bust to Mr. Appellee?
That's not in the record, Your Honor. I've seen it because I've been up to the college and looked at it, but it's the size of it isn't in the record. What is in the record is that there is a bust of Mr. Appellee.
And what is the wording, the full wording in the record? Is there anything sort of talking about what a great guy Mr. Appellee was? Because let me tell you what I'm driving at. If there's kind of a memorial to Mr. Appellee associated with the paintings, then one might argue that that supports the view the paintings were supposed to stay there and not be sold, right?
I believe that the plaque and the bust, the fact that there's a bust on the plaque, it is a representation of the gift itself, the act of giving, the donation, to commemorate the event of the giving. Certainly, the Appellee Foundation was very concerned about the plaque and the bust. It consumes 4 paragraphs of the 5-paragraph gift letter. Your Honor?
Well, yeah, it seems like they were more concerned about the bus than they were about Coe College. It goes on for paragraph after paragraph after paragraph with kind of minutiae about this plaque. And it strikes one that maybe the purpose, or a purpose, was to commemorate Appellee. And indeed, the letter, as I say, I mean, it's not a lawyer letter, it doesn't look like, but the letter that we look at spends a lot of time on the plaque and not much on Coe College.
I think that's right, Your Honor. The plaque certainly was to memorialize a person, less so about the paintings. There are the words in the stipulated facts to answer Justice Mansfield's question. There are the words of part of the plaque in there that says the fruits of Iowa, which are the name of the 7 paintings collectively, were to be given. So those words are in there. And yes, it was a commemoration of a person with no direction whatsoever that the plaque remained with
I want
the
to ask you a
paintings.
question when you say no direction. If you're saying it was an out-and-out gift, shouldn't the gift letter have said, the Appellee Foundation Board of Directors have approved that the Grant Wood paintings be given to Coe, period? Wouldn't that be clear?
Well, as Justice Appel said, it wasn't written by a
No,
lawyer.
but it was written by the person who was handling the obviously mammoth amount of money. So wouldn't that have been, do you think that would be clear? That would be certainly an out-and-out gift?
I don't think there's any question there could be clearer
Okay.
language in the
But
letter.
I guess what I'm getting to is they added more, and we can't just ignore that more, can we?
No, you certainly can't ignore the words of a contract or a gift instrument. They have to be read as a whole, as the case law says. It have to be read in context, which if you look at the entirety of the stipulated facts in this case, this was a gift that was changing from a loan to a different situation, the relationship.
But the bust and stuff happened after the loan, right? The bust and everything was created when it was gift time.
At the time of the
I
gift.
think the state made an argument in its brief that I thought was persuasive. How do you bifurcate the bust and the memorial from the paintings? So if you say that they weren't intended to stay together, if you start shipping them around or sell them, if you sell the paintings, does the bust go with it? And wouldn't that be kind of weird because it says to Coe? Or would you separate them? And then he says, I gave these things and those things are now gone. How do you separate them from each other?
I think that the plaque has to be looked at in terms of what it was. It was separate from the paintings. The paintings were dealt with in paragraph 1 of the letter. The bust and the plaque were dealt with separately. The record shows that the college has loaned out the paintings over the years, and there's no record showing the plaque has gone with the paintings when they've been out on loan.
I think the
So-
district court ruled that would be okay, kind of a way of keeping the paintings funded for upkeep. Is
That's-
that correct? Did the district court order say loaning it was not a violation?
That's correct,
Okay.
yes.
What are the practical consequences of the reclassification of these paintings as restricted? How does that affect Coe College?
Thank you, Your Honor. That goes to the heart of why we're here. These paintings have been in the unrestricted bucket, if you will, for accounting purposes for 40 years. The college has made major long-term financial decisions based on that categorization in its books. And the 2016 opinion of the auditor really put that on its head. So the problem here is that CO has relied on that being in its earning endowment, and in the earning endowment, it's a $5.4 million reduction in that value. And so that earning endowment is used for all purposes. It covers the entirety of the college and the college's educational mission. The educational mission is the very reason why these gifts were given. If you recall, the foundation's purpose was to give gifts to promote the well-being of mankind, and it lists scientific, literary, educational, all these purposes.
Is Co-College solvent now, or do you have to sell these paintings to keep the doors open?
Your Honor, that is not in the record. What we do know in the stipulated facts is that with the earning endowment being reduced, that impacts Co-College's federal reporting requirements, so which are what the college or what the federal government looks at to determine whether Co can be involved in student loans, so any federally guaranteed program. So the solvency of the college is certainly not in the record, but
What's the impact of that? Are you worse off? Are you in a different, or are student loans costly, or how can you put a dollar figure on the impact of that accounting change?
So if you look at appendix page 27 is really where the numbers are. That is a 2016 financial report. And that shows that the $5.4 million has been reduced from one bucket, and $3.45 million, which is the value of the paintings as solely as artwork, the artwork collection, that number has increased. So the numbers are on page 26, and that's of June 30th of 2016. So the earning endowment numbers are, what's not in there is the debt ratio, which is used for the accounting purpose, federally education reporting requirements. So the endowment to the debt ratio is not in the record anywhere.
But none of the accounting issues are relevant to the donor's intent, right?
Correct. Yes, so the donor's intent is really what the whole word permanent home is about, and you have to look at the outside of that letter, which is the purposes of the foundation itself. The fact that the Appellee Foundation dissolved on May 2nd, 1977, so just over a year after the gift was made, they were in the process of doing what the foundation was designed to do, to give gifts to charitable organizations.
Well, let me ask this, and I want to slide into the side party argument. The purpose of donating these paintings was to give them a permanent home so that they could be viewed by students and the academic community and citizens generally. Is that now impossible?
Your Honor, I think you're including some words that weren't in the letter as well. The letter didn't say that they were to be viewed or used for education.
Well, it says permanent home and hung in the library, and I guess I inferred from that meant eyeballs would be on the painting. Am I wrong?
No, you're not wrong. But the word permanent here, the Tennessee case from the 1920s is instructive. The Tennessee case that I cited in my brief talks about how the word permanent is not perpetual. Doesn't mean a perpetual in trust. There are so many things that are not in that letter that could have been in that letter to make it so that the paintings had to be.
The problem is that it's not permanent by itself. Or it's permanent with a different word. If the letter had said, I am making a permanent gift of these paintings to Co-College, I'd probably tend to agree with you. But it says Co-College shall be their permanent home. That's a little different, right? I mean, we read words in context, right?
We do. All of these students here today probably have a permanent residence. They may have a residence that's not so permanent here in Iowa City, but a permanent residence, we all know that doesn't mean it will never ever change. It doesn't equate to not changing, which is what the Tennessee court said.
What relevance do we put on, as I understand it, the college itself started some sort of petition or movement where they were asking to receive the paintings for the purpose of keeping them in Cedar Rapids, given that the artist was from the area, and making them available. If that's correct, what weight do we put on that in determining what the donor's intent was?
That comes from the newspaper article from March of 1967, or excuse me, 76. So take that for what it's worth, give that whatever weight it's worth. That's not something that the district court chose to consider. But the point is that
On the question of remedy then, let's assume that that was the purpose of the gift, was to allow it to be displayed in the Cedar Rapids area because it has unique cultural property value for this area. One of the remedies we can afford, Co., is changing the recipient of the gift under Cypre. And if we find that there's another recipient who would display the artwork in a way that it was intended to be displayed, would that be an acceptable remedy to Co.? They would no longer have the painting, and it would be donated to some other recipient who would carry out the donor's intent of making it available in Cedar Rapids.
I see my time is up. May I answer your question?
You may.
Thank you, Your Honor. That is not an acceptable remedy to Co. Co is certainly grateful for the gift it was given, and there's certainly value in the paintings, even if they are deemed restricted, certainly a $3.45 million value. So no, the college certainly would not want that to be the remedy, Your Honor. Thank you.
Ms. Baumann, thank you as well. Ms. Smith.
May it please the court, counsel. I am Chantelle Smith with the Attorney General's Office and am here today representing donor intent and the public's interest in the gift of the Grantwood art to Co College. I think that the court has discussed here what our position is on this, which is that this was a restricted gift to Co, and that it's plain from the gift letter that it was restricted. The fact that Co has treated it as an unrestricted asset for decades now is not a burden that the gift has to bear. Here, Co is essentially saying, well, we made a mistake, which is noted in appendix page 27. The auditors say, Co has made the determination that they made a mistake, which certainly they did. Now it's time to remedy that mistake, and as Justice McDonald pointed out, the remedy here for Co, it's kind of careful what you wish for. The remedy here is that then we transfer the asset over to an entity that can, in fact, honor that restriction.
Can I ask a question about this language? It says, and that this would be their permanent home hanging on the walls of the Stewart Memorial Library. I mean, does anybody really believe the Stewart Memorial Library will be there forever?
Absolutely not. And that's what's sort of interesting about the district court's decision. You don't get to go back and say, hey, that's not what I meant. When we talked about what I call traveling the art, I think those who are more educated in art call it touring the art. But when we talked about traveling the art, my point was, well, technically, it says permanently hang on the walls. So we would expect to have a conversation about that, and I told the judge, I don't have all the information before me, but certainly I don't anticipate that we would say those paintings cannot be removed from the wall. They have to be maintained, they have to be cleaned, they have to be taken care of. So certainly that is going to happen, and
What happens when the library's gone?
when the library is gone, then that's when Cypre comes into play, right? That's why we have Cypre, that's why we have a MIFA, is to say, if something happens, we don't expect that donors, gift givers, have a crystal ball. None of us do, right? We're sitting here, we're expecting that Co College will exist forever, number one, and that the library will exist forever.
How do you determine the intent of the donor? I mean, there's this newspaper article, but that wasn't part of the letter. I mean, how do you determine, you go outside the letter and look at a newspaper article to determine the intent of the donor?
I think you could. I don't think you need to.
Today they'd call it fake news or something, you know?
Well, possibly, yes. I think you could, but you don't need to. I think the letter is clear that the donative intent here was these would hang on the walls of the library. That's what they anticipated. That's what they were looking for. That's what the letter says. Co would be the permanent home. They did not mean, I'm sorry.
You seem to be conceding that at some point the doctrine of cypre would apply or could apply, right?
Absolutely. To save this gift from failure, absolutely.
So there's, there's that case from Tennessee where the Fisk University was allowed to sell some of the George O'Keeffe paintings that have been given to it. Now, so at what level, what would Co have to show in order to lift the restrictions or lift them in part, say sell one or two of the paintings if it needed to? What would the burden be?
Actual impossibility or impracticability of exercise of that restriction. So.
Well, there's two different terms. One is impossibility, but the other is impracticable. And, I mean, here's the problem. I mean, the problem is because of the accounting treatment, we end up having a difficult financial situation at Co. Now, is it impossible to hang the paintings in the library? I guess I would say no at present. But cypre also has this notion of impracticability, and that there's some point at which, even though it may not, theoretically it's not impossible, if it becomes so impractical that it ultimately defeats the intent, cypre might kick in. One of the questions in my mind is, what does that impracticality mean? How high does it have to go? And can you enlighten me?
Well, I can try. Impracticability, I think, often blurs with impossibility or sometimes blurs with impossibility. But in this case, for instance, in Kolb, which this court decided, Kolb and the city, you're looking at natural, unintended consequences, occurrences, circumstances. Here, that hasn't happened. So it isn't like we're looking at it and saying, well, it's just not going to work out for them. It could work out for Co. Co could have internal remedies. Co could do something within its own organization to fix this problem, whether that's fundraising or, I don't know. I don't want to speculate as to what they could possibly do. There are other cases where you have art where you've got an institution that is failing.
Well, they're kind of in a box, though. It looks to me like there's been some reliance on what arguably is erroneous accounting. So there's been some reliance on it, and they've structured their student aid and who knows what all. I'm not sure what the record reveals, but they've structured their financial affairs around it. Then all of a sudden, whoops. And so I think we have to say that, we have to recognize the problem, and to what extent does it mean, we should be editing and fussing with this letter. If the original board was here and realized that Co was in this kind of box, again, I'm not sure what impracticality means. What you're saying is it means very impractical.
Well, I think there are cases where you have a museum, for example, that is going to shut down. They want to sell pieces of art. And the response from the community, because the community is usually very upset about these things, the response from the community is, no, go fundraise and sell other pieces of art. The response from the museum and from the court sometimes in those cases is, if they sell those other pieces of art, they are going to be sanctioned by the associations. They will never be able to accumulate additional art. They will never be able to loan art.
But this is not an art museum, it's a college. And so that's why I think maybe the George O'Keeffe precedent, where you had a university that was in financial difficulty that was allowed to sell, or at least remanded for the application of cypre, at least a remand was granted to allow the potential application of cypre so they could dispose of some of a collection of paintings that were given under a restriction. Why isn't that met here? Haven't they shown enough in terms of a financial bind that they're in?
Co is not standing before you today. Ms. Baumann was asked this earlier. They're not standing before you today saying the doors are closing, we are turning students away, and students are going to have to go work jobs and earn $100,000 a year in order to pay for their education because we can't fund it. They're not standing in front of you today. They didn't stand in front of the district court and say that. That's nowhere in the record, and you've not heard that. Now, if that were the case, certainly we'd step back and say, okay, we have an issue here. again, I don't think that the gift should have to bear the burden of their mistake. But as you point out, that is a possible reality for Co. It is not their reality today. The library still stands today. They made the argument, we can't expect the library to stand forever. What if it burns down? If it burns down, we're back at the table having a conversation about what do we do here.
So you're on the winning side of a trial court ruling that found the donor's intent was to restrict the gift. What's our standard of review? Are we de novo, we can make up our own minds? Or how much weight do we give the trial court factual finding?
I think that you give the district court deference in her decision here.
What if you'd have lost down below? You still feel that way? Well, because I'm saying that because there's a difference in opinion on the standard of review, and I was kind of curious. I thought it was, usually that's not something that's terribly disputed.
Well, you know, I don't mean this to sound egotistical in any way, shape, or form. If it was de novo, or if you deferred to the district court, I think our position prevails. But in this case, unlike Kolb, in Kolb, you are looking at the application of Cypre. In this case, you are looking at the interpretation of the gift letter.
To what extent should ethical guidelines regarding disposition of art, whether it's American Museum Association, American Association of Colleges, to what extent should that be relevant with respect to the remedy or the way we think about the case? So as I understand it, those guidelines indicate that no holder of art or cultural property like this should be able to sell it for the purposes of boosting an endowment, right? You can sell art to acquire more art, but not just for financial reasons. Is that relevant?
The best practice is that you sell art to purchase more art. You don't sell it to fund your operations. I think those are best practices. As far as I know, Co is not a member of those associations, and ironically, this comes up somewhat regularly. I think it's a best practice. You know, I hate to stand up. You know, we want to protect donor intent here, but at the end of the day, those are best practices. Here, we have a gift letter that says these are to hang on the walls of the Stewart Hall Memorial Library. They are not to be put on eBay or sent over to Sotheby's for sale to the highest bidder. That's what we're talking about.
What's your position about the fact they've been loaned out over the years? Is that a violation of the restrictions?
Well, as I told the district court, we were unaware of the fact that they were being loaned out. And honestly, again, I don't have all the facts before me, but being the person who reviews these primarily, I wouldn't take issue with it, because I would look at it and say, look, you got to fund. This is important art in the state of Iowa. This is important art in this country. There was no trust set aside to take care of it. If you need to loan it to the Whitney Museum in order to get the funds to preserve it for all time, then let's do what we have to do to preserve it for all time. We don't say it hangs on the wall.
Were the paintings hanging on the walls of the library at the time the gift was given?
I'm sorry, I didn't hear you.
Were the paintings hanging in the library at the time the gift was made?
That's my understanding.
Prior to the gift being made, how are the panels maintained? Did the Appellee Foundation maintain them?
That's not in the record how they are maintained, or if they are maintained.
No, I'm talking about before the gift, when they were just loaned to the code. Is there anything in the record of how they were maintained and who paid for
There's
it?
nothing in the record about the maintenance of
I'd like to ask you a question about page 27 of the appendix. That's the financial statement, note 13. The Co talked about how it has a swing of 5.4. It reduced their unrestricted net assets by 5.4 million. But there's also an acknowledgement that it increases the permanently restricted net assets by 3.4. So should those numbers offset each other? Are we talking about lesser of a margin than 5.4 million? This seems to be the only place in the record that has much numbers that we can actually bite into.
As to the offset, you know, this is a little odd for me. I have an accounting degree, so I'm familiar with these things. In Co's world, this is significant because unrestricted are free dollars.
Sure.
So, in our
But the
position,
restricted of 3.4 is nothing to shake a stick at, right? I mean, that's also something that goes to a ledger?
absolutely nothing to shake a stick at.
Yeah.
I would love to have that.
Me too. We could quit our
Yeah.
day jobs.
Yeah.
Yeah.
Nothing to shake a stick at, but I guess what I'm saying is we didn't really look at the margins. From our perspective, if Co wasn't so fortunate for this to now be worth millions of dollars, if today it was worth $5,000, we'd be taking the same position. So the margins and what's it worth or what's it not worth, it becomes irrelevant in some way, and the fact that there's donor intent here and we're upholding this gift, which is a gift that is given to the public as well. So,
But do you think we would be here today if there had not been that drastic change in their accounting?
well, I think it certainly motivates Co.
Yeah.
Absolutely.
Are the paintings an institutional fund or a program asset for purposes of the statute?
Our position is under a MIFA that it is a program-related asset. It is not an investment. Co has been booking it as an investment. Our position is this gift letter says, no, this is not a cash cow for you. This is an asset that you hold that relates to education and public appreciation of art, and you, Co, are the means by which that happens. So it is a program-related asset like the buildings that Co uses and other things that it uses to get its mission accomplished.
They have art majors, art classes, art history classes. Does that help show that it's a program-related asset?
I think that helps, yes, but even the fact that it's on display for the public for appreciation and viewing by the public, which otherwise it might not be, I think is instrumental to that as well.
You know, the Appellee Foundation was dissolving at the time this gift was given. So I think we can anticipate that they had an end in mind. They were ending their existence. And they used a language, you know, where it would be a permanent home. Does that kind of seem like loose language when a legal entity is coming to an end and they want to provide restrictions that would continue to apply to the donee?
My time is up. May I answer your question? I don't think it's loose language. I think, especially to non-lawyers, we lawyers in this room can, I mean, we can pick for days on end. That's what we're trained to do. But I think to the Appellee Foundation and the members of that foundation, they were looking at it just saying, we held this art in Mr. Applee's memory. He wanted this to be available to the public. He wanted people to appreciate art. It's permanent, hanging on the walls of the library. There's not much more to say about it. Why say permanent if you don't mean permanent, first of all, as Justice Christensen pointed out? What else is there to say? Permanently hang on the walls of the library. Then they dissolve and they go about their business knowing full well that the institution that held this art for them for decades before and partnered with them would do the same.
The loose language that I was referring to was to call it a home. And this seems to be the word that's being used to indicate that this was a restriction that would prevent what Co now wants to do.
I think
Is
home.
that the kind of word we would use to describe?
I think home kind of conveys a message, at least in my mind, that this is their home. This is where they will live. This is where they will stay. They may possibly venture out now that, you know, we're looking at it thinking we've got to do something with this art, but this is where they live. This is where they come back to, and this is where they stay forever, safe and taken care of. I think it's an important word.
Thank you, Ms. Smith.
Thank you.
Rebuttal? Ms.
Thank you,
Baumann?
Your Honor. The Attorney General's office mentioned the Kolb case. I'd like to talk about that for a moment. In the Kolb case, this court applied the statute of the Iowa Trust Code, section 633A.5102, which is the codification of the common law doctrine of Cypre. In that case, the court looked at the general charitable intent of the gift. This court said, we conclude the settlers' general charitable intentions were to memorialize a family member by maintaining a flower garden for the enjoyment of the public and this charitable purpose is superior to the specific language of the trust regarding where the funds were to be spent. Likewise here, the charitable purposes of the foundation were far greater to promote the well-being of mankind and to give gifts to charitable organizations to promote that well-being. That's far greater than a single line in a gift letter that says Stewart Memorial Library.
It's a little different. I mean, that case, I did read it because the chief wrote it, I think, so I figured I better. But as I remember, what the facts were is the garden ended up being moved. So this isn't something like the paintings are going to be moved. This is wiping out a restriction that in order to make them wholly alienable, that they could be sold. So, I mean, that's sort of cypre on steroids, isn't it, that you're asking for? I mean, you're not just asking to move the paintings around, you're asking to make them, in effect, a cash asset, right?
Well, it's very similar to the Kolb case, Your Honor, in that the reason that the garden moved were the economic circumstances of the time. So when the Kolbs made the donation in memory of their grandson, they couldn't have anticipated the changed circumstances in Storm Lake at that time. So at the time that the garden was moved, the city had determined, wow, this is a different time, this is a different place. We need to move the garden in order to promote the city and have a vibrant city.
So is
Same
your
thing
case
here.
a little premature? The garden hasn't moved. You guys are, is where they were, where they are. There doesn't sound like anything's changing.
The paintings haven't moved, but the numbers have moved,
Well,
Your
that's
Honor.
the numbers. I mean, we can't have it both ways. You say it's not about the numbers, but it kind of seems to be about the numbers.
It's about the numbers. It's not about an accounting error, but it's about the buckets, if you will, that the
What does
numbers
the
were placed
record
in.
reflect on the practical consequences of the numbers? And I think Justice Waterman asked several questions in this regard. Let's say that the district court is affirmed. What does the record show in terms of what that means on the operations of the college on a day-to-day basis? Because the only thing I read is, well, now it's classified differently. I don't know enough about how colleges are run. I don't know why that's relevant.
Your
and
Honor,
what it
may I
means.
answer the question? I see my time's up. Your Honor, if page 30 of our appendix, paragraph 21 of the stipulated facts, as well as the pages we've talked about previously, are really the only parts of the record that talk about the financial impact on the college going forward. It impacts the college's federal reporting requirements, which impacts everything that the college does financially.
Well, let's assume it impacts the reporting requirement. What does that mean? Like, what happens to the student body? What happens to the curriculum? What happens to the faculty? Where is any of that evidence? I don't know what the reporting requirements entail or what the consequence is.
May I answer that additional
No,
question?
you still have more time.
Oh, okay.
yellow.
I thought I was up. I'm sorry. To answer your question, it's worst case scenario. The college goes out of business. If it can't have student loans, it likely cannot operate. So the federal reporting requirements.
Is that in the
that-
record, that it's student loan ineligible because of this accounting change?
That's not in the record that it makes it
So
student
what
loan.
does the record reflect on what is the consequence of this accounting change in terms of the financial situation of the college and its operation?
It's limited, Your Honor, to the pages I've mentioned. Are there additional questions? If not, Co-College asks that the court find that the language of this letter is an unrestricted gift. If you find it's restricted, there are 4 avenues the court can turn to under the Cypre doctrine, generally the 2 prongs of up MIFA, as well as the common law doctrine of Cypre and the statute that codifies Cypre. Thank you.
Ms. Baumann, thank you as well. Ms. Smith, thank you again. The case of In re the matter of Cole College for the interpretation of the purported gift restrictions is now then submitted to the court, and I would ask the bailiff to adjourn.